Good morning, my friend. Today I'll talk about confidentiality, chapter 5. Confidentiality. First, I'll give you the important detail, then I'll explain later. Importance of confidentiality in paralegal practice. Paralegal must mean you have to, must maintain full confidentiality to ensure open client communication. Confidentiality and loyalty are essential for effective service and trust. Like paralegal must have all information relevant to the client so that he can provide the effective service. Unless the paralegal have full unreserved communication, whether relevant or not, and paralegal must maintain confidentiality, and client must feel comfortable that his information should be kept secret unless it is essential to be told to the concerned person, and it must be used for the benefit of the client without any express request by the client. It means that express request, whether client give you the request or client requests you, or client gives you the instruction, please do not reveal my confidential information to third party or any other unconcerned parties. It doesn't matter whether he instruct or not, it is to be protected. And paralegal duty of loyalty and confidentiality are essential throughout professional relationship. So this confidentiality should be in strict confidence that all information concerning to the business affair of the client required in the course of professional relationship, unless situation falls under one of the exception discussed later. One more thing, it doesn't matter whether this information, whatever the client is providing you, is publicly available, like in the social media or in the news or other thing. Whether or not it is available, you have to maintain the confidentiality. You cannot justify yourself that because it was available in the media, I disclosed that. No, you cannot do that. You have to maintain confidentiality. Scope. Another consideration is whenever third parties are involved. Third party means the family member, friends. During client meeting, you should prevent inadvertent disclosure or conflict of interest. Disclosure of client information is permitted only under specific circumstances, like required by the law or required by the tribunal or some other situation. I'll discuss it later. Because third party doesn't have any obligation to maintain the confidentiality, that's why you have to take consideration about that. When the third parties are involved, you have to tell the client whether he is comfortable or he authorizes the third party, because your confidential information should be should not be protected. If the third parties are involved, you have to explain the client. So paralegal duty of confidentiality, as I discussed, is not absolute. So in some cases, he has to disclose the confidential information if required by the law or by the tribunal or some other situation where he can disclose. I will discuss it later. So next is scope and duration of duty of confidentiality. It begins when the professional relationship starts, including prospective clients, current clients, or regular clients, and it continues indefinitely. So even after the relationship ends or the client death, it should be maintained. It doesn't matter the client dies, still the confidentiality will stay remain same. You have to maintain the confidentiality. One thing, the disclosure with the client authority. If a client authorize, you must obtain the express or implied client consent for disclosure. Express client should be documented in writing. Express mean the client himself authorize you to, you can disclose my information to such and such person, or you can disclose to that person. It should be in writing. Implied consent may be inferred based on the context of the retainer, because that is implied consent that when you are hired by the client and when you go in a small claim court, you have to tell those small claim court people and other concerned people that this is my client and he want this sort of remedies. So unless you spoke to them and you reveal some information, you cannot proceed with the case. That is implied consent. And there are some disclosure without client authority. Mandatory disclosure in limited situation, including prevented preventing imminent death or serious bodily harm, and defending against the allegation involving paralegal conduct, or establishing or collecting fee, that is permissible. Before that it was mandatory when required by the law, tribunal, or law society. Permissible: preventing imminent death, seriously bodily harm, and defending against allegation. Permissible in establishing and collecting fees. Permissible in securing legal advice about the paralegal action, or detecting, resolving conflict of interest in firm transition. And when you are dealing with the mandatory disclosure requirement, comply with the legal mandate but reveal only the necessary part of information, not more than that. Only the limited whatever is required, not more than that. And protect client privilege whenever applicable. In permitted disclosure example, preventing imminent harm must be based on reasonable ground of risk and necessity. If, for example, somebody showed you that some sort of weapon or something, I'm gonna harm that person, I'm gonna kill him. So that is imminent danger, that he showed something and you, based on the reasonable ground, that is permitted disclosure. Defending against a specific allegation with a disclosure limited with whatever is necessary, and securing legal advice about professional obligation, that is permitted disclosure. So responsibility within a firm: paralegal must ensure all staff and associate understand and uphold confidentiality, and the office procedure should safeguard client information, because when we are working in the firm, that's a big firm, there are so many clients, so many lawyers are working in the same organization, and one client information may be in confliction with the another client within the firm. So make sure that it should not happen. Either you have to make some preventive measure or to withdraw. We will discuss it later in other chapters. So in that firm, all member of the firm, including employee, anyone involved with the client matter, and they understand and abide by the duty of confidentiality set out in paralegal rules. Ultimately, paralegal is responsible for any discrepancy if it happens. So one thing, when paralegal is working for CSO organization, paralegal working with the civil society organization must maintain confidentiality of the client. Maybe sometime must ensure that the confidential privileged information concerning to the client is disclosed only with the client informed consent or required by the law, because you are working in CSO, civil society organization, but working for the client. Basically, you are protecting the client interest. So, client confidentiality should be maintained. That's a tricky point you have to understand. Even if you are disclosing with the client consent, you must take a written authorization. That is important. So, I'm again just repeating the same thing, but you have to understand must or may. The questions come, you have to think about what is required must, what is required in may. Must disclose confidential information to the competent jurisdiction by the law society, by the tribunal, or the law, by the order of the court. That you have to must disclose, but not more than necessary. Now, may. Paralegal may disclose confidential information in order to prevent death or seriously bodily harm, or defend against certain allegation or claim, or to establish or collect their fee, or secure legal advice about the paralegal proposed conduct, or may disclose confidential information to resolve conflict. In all cases, the paralegal must not disclose more than necessary information. So that is may, keep in mind. For documenting and record keeping, for any disclosure, paralegal should conduct reason, authority, and method of disclosure, copies of relevant documents or order, details of parties involved to the disclosure. Another thing, must disclose or justified disclosed are the same, required by the law, required by the tribunal, or required by the law society. So one more thing, if you feel that at some point that you are unsure whether to disclose, whether not to disclose, at that situation, paralegal should seek legal advice from the lawyer experienced in the relevant area, like criminal law, served in the police search or warrant, of tax law, faced with the demand of information by CRA or legal obligation, must comply with the statute, court order, or other demand or request, compel to disclose confidential information subject to the disclosure of assert disclosure obligation. You should assert the privilege on the client behalf if applicable and appropriate. So you have to maintain the privilege in case somebody asks, some police guy asks and demand you to reveal the information about your client. You immediately assert the privilege. No, I cannot. If they insist, you can contact the higher approach like criminal law representative and other concerned agencies to help you out. And in case the paralegal is has confirmed that there is no legal obligation to disclose client confidential information, paralegal must not comply with the demand or request without client authority, and you have to must inform the client about somebody is requesting to get your information, or must obtain the client authority. Another situation may arise that you are trying to contact the client and somebody is asking the information regarding the client, like authorities, police and other, and client is not located. You are trying to contact but client is not answering. So the paralegal should immediately assert the privilege and decline to disclose the client information. As I discussed earlier, must and may. Furthermore, permitted disclosure. Paralegal are permitted but not required to disclose confidential client information without client authority in five situations. Permitted but not required. Again, it's further explanation in the same book. Before must, may, and now permitted in five situations. What are the five situations? Again, to prevent imminent death or seriously bodily harm. Number two, defend against certain allegation. Number three, to establish or collect paralegal fee. Permitted disclosure not required. To secure legal advice about the paralegal proposed conduct, and to detect and resolve conflict of interest arising from the change in employment of the composition or the ownership of paralegal firm. These are the five situations. It's permitted disclosure not required. So handling misconduct. If paralegal is working in a firm and firm conduct is dishonest, fraudulent, criminal or illegal, paralegal must advise the responsible parties within the organization to stop the conduct. So there is a ladder approach, and this is further explained in another chapter, because in whole book everything is scattered. You have to collect the pieces from different chapter and combine them to make it understandable for you. So in further detail in page number 54, it again explains how you should handle the misconduct, like whistleblowing. So paralegal who learn that the organization and the firm has acted or acting or intend to act, acting or intend to act in all three situations, fraudulently, criminally or illegally, with respect to the matter of which the paralegal was retained or employed. That's a ladder approach. First, paralegal advise the person who gives the instructions to the paralegal and the chief legal officer, or both chief legal officer or CEO. So that two people, either the person who is giving instruction, chief legal officer or CEO. That is a first approach. Even then, if dishonest, fraudulent, criminal or illegal activity is not stopped after informing them, then the next approach, the paralegal should go a little bit further higher and inform the board of director or board of trustee or the committee that the dishonest, fraudulent, criminal or illegal activity should be stopped. That is the second step. Even then, if organization continue to do the same thing, and despite of paralegal advice, the paralegal should withdraw from the firm or organization. That is the three steps. You should make up in your mind that you will not be forgetting those points. First, who gives instruction, chief legal officer or CEO. Second, board of director, board of trustee or committee. Third, withdraw. Security of court facilities. Reporting dangerous situation. Paralegal must inform security if they reasonably believe a dangerous situation is likely at the court facility, and client consent or exceptions required. confidential client information can only be disclosed with the client consent or under exception like preventing death or seriously harm. If you feel like that your information may reveal the identity of the client, you can call anonymously to the person who is responsible for the security of the court. Hey, you should add the security. There might be some dangerous situation occur in the court, without telling them who you are or without revealing client identity. Anonymously you report it, so they know what to do at these circumstances. You did not reveal confidential information. You did not violated the instructions, and you save the people who might be in danger by informing anonymously. So duty to report misconduct. Reporting other licensee misconduct, paralegal must report evidence of misconduct to the law society unless it breaches client confidentiality or unlawful. So when some other paralegal are doing some thing that is not authorized, you can report to the law society, but in good faith. Report must be made in good faith without malice or ulterior motives. And this misconduct to report applies to paralegal's own conduct and as well as the other licensee. If his paralegal is unsure whether to report about this conduct or not, he can take advice from the law society directly. How? By contacting the practice management helpline or indirectly through another licensee. Prohibited use of disclosure of client information. So when you are discussing within the office or in the public, avoid casual conversation. Client information should not be discussed casually in public or personal setting, including with a spouse or colleague, because some might overheard and they might tell another person who is related to the client, and the information is available to the party who is opposing the paralegal own party. So another thing is discussion is prohibited or use of disclosure of client information that secure the document. Client document must be kept outside of the reach of unauthorized individuals. Maybe you are sitting on a table and so many papers regarding your client matters are kept on the desk, and there might be some headings or other things. Another person comes in your office and inadvertently sees the document. Oh, he is the client of that person. He might use that information against you. So paper should be secured and locked and not inadvertently lying on the table unattended. One more thing is border searches. When you are crossing international border and you are taking your laptop, your papers, your other things, make sure these are the confidential information, because during search that they might see it. So you have to secure those things accordingly. Like if you electronic devices, you have to protect it. You have to make password and other security measures should be maintained to ensure the confidentiality when crossing international borders. And for this thing, that paralegal should develop policies and take precautions that safeguard the client information during international travel. So these are the things which are required by the law society to know regarding the confidentiality. I just highlighted the important parts of this chapter, but you have to read the whole chapter thoroughly so that no point is missed during exam. So at the end of chapter, I'll give you 5 bonus questions. I prepared it myself. I didn't take from any source. I prepared it from the new book, and these are my own questions. I did not take from any samples. So question number 1. When does paralegal duty of confidentiality begin? There are 4 choices. When the client signs the retainer, as soon as professional relationship is established, after the first payment is received, or only after the first meeting. You have to select one answer. Question number 2. Which of the following is the exception of duty of confidentiality? If the third party requests information, or when required by the law, tribunal order, or if the client family asks for the information, or when the information is widely known publicly. Question number 3. What should paralegal do when faced with subpoena to disclose confidential client information? Number 1, disclose everything related. Number 2, refuse to comply without consulting client. Number 3, disclose only information legally mandated and assert privilege when applicable. 4, ignore subpoena. Question number 4 is paralegal may disclose confidential information without client authority in order to collect fee or prevent financial loss, or to share updates with client family, or clarify misunderstanding with the third party. Question number 5. What must paralegal do if they share client information with employee or other firm members? First choice is ensure everyone sign confidentiality agreement, or trust them to handle the information responsibility, or implement and enforce procedure to protect confidentiality, or disclose client details only when convenient. I'll attach these questions at the end of this video, and if you need more questions or related to this chapter with the minimum charges, I can share you on my email, or you can call me anytime. Thank you very much, and see you in next chapter. Bye.